And hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal educational content, and today is the day that I will earn that subscription. For today's story, we are dealing with the chess drama in the form of perhaps beads that might vibrate, or so the zeitgeist would have us potentially believe. This is the ongoing case of Hans Niemann versus Magnus Carlsen and others. In our initial complaint review, we read the complaint by Niemann, who made some accusations against some people. Now, the accusations against Carlsen looked like they might have some potential. The ones against chess.com seemed very shaky, and the ones against Hakura Nakamura seemed like non-starters. Well, I saw today that a response motion to dismiss was filed by Magnus, and so I scheduled the stream and titled the stream appropriately. And while we were prepping, the motions to dismiss by chess.com, as well as chess.com's leader, Daniel Reich, have also dropped, but not so far, at least on the docket, has the response of Hakura Nakamura dropped. So maybe it's been filed and just simply not put on the record yet, right? Maybe it's sitting on the clerk's office waiting to be. So maybe by the end of the stream, we will have his motion to dismiss as well. But until we do, we can cover what we have. So that's what we're going to do. So I hope that all that works out for everyone, because that's what we're doing. So let's start with Magnus. That is not what I want to share. I do not need to share the docket. Let's try again. Share the PDF. That's what I need. Okay, great. Let's show that on screen. This is in federal court in the Eastern District of Missouri, where the chess tournament was held. That was the source of this row. And some of the statements may have been made within the borders of Missouri by Magnus and possibly chess.com, although their link to this is tenuous and it's not clear that Hakura did anything with connection to Missouri. So I would expect a motion to dismiss for lack of jurisdiction, for lack of personal jurisdiction, among other reasons, but we'll see what we have from the parties. So first we have from Magnus. This is Magnus's motion to dismiss under both state law for an anti-SLAPP and federal procedures 12b6, which is failure to state a claim. All right, let's give that a shot. Pursuant to Connecticut statute and federal rule of procedure, Magnus Carlsen moves to dismiss with prejudice each of 5 claims asserted against him filed by Hans Niemann. He'd like the case to go away. As set more fully in the accompanying memorandum of law in support of defendant Magnus Carlsen, which we will read, under Connecticut general statutes and federal rules of civil procedure, Niemann's claims fails under both Connecticut's version of the anti-SLAPP and federal rule 12b6. As a matter of law, his state law claims are barred by Connecticut statute. We'll get into whether or not that's true or not. If we were in Connecticut court, potentially, but federal courts are a little bit hit or miss about whether or not they recognize state anti-SLAPP. Some states, some federal courts do, and some federal courts don't, and we'll see what their support for authority that this federal court should recognize Connecticut's anti-SLAPP. So as a matter, if this were in state court, maybe, but we're not, so we have to see whether or not we're bringing that in. They should also be dismissed under Federal Rule 12 because they've not alleged and cannot allege facts to support them. Okay. Niemann's federal antitrust claim falls under Rule 12 because it's set forth in below. Niemann has failed to allege elements required to state a claim. The antitrust claim is kind of weak. To say that there's and also that he's a harmed party in this context is a little bit nebulous because Hans Niemann doesn't really have a competing business or something. So his claim to an antitrust violation seems a little bit difficult. In support of the motion, they rely on the memorandum of law, chess.com's motion to dismiss, and their memorandum of law on all pleadings. So he's also adopting chess.com and what they have to say, which, fine. There's nothing preventing the defendants from working together and collaborating and filing stuff together, filing stuff separate. They're independent parties. They can do whatever the hell they want. And so we would like dismissal. Okay, fine. So let us read the motion to dismiss or the memorandum of law to support this and see what we have to say on this. Okay. After years of trying to curate a reputation as the bad boy of chess, Hans Niemann wants to cash in by blaming others for the fallout for his own admitted misconduct. I mean, he's admitted to some misconduct, to be sure. He's admitted to cheating online on 2 occasions, I believe, by his own admission. But that he was relatively young and, you know, maybe that's some of it. But whether cheated in person or at this tournament is potentially a separate issue, or maybe not, but we'll see. Niemann's amended complaint concedes that he has a well-known history of cheating. But rather than dealing with the unsurprising consequences of the action, Niemann now seeks to shift blame to world chess champion Magnus Carlsen. Well, we got to get that in there. World chess champion Magnus Carlsen, okay. And among others, claiming a wholly implausible conspiracy to defame and boycott. The conspiracy was also a little bit perfunctory. So yeah, chess.com. There's some problems there. Niemann's claims all fail in the face of the amended complaint. Even accepting all the allegations are true, Niemann cannot escape his own admissions that he cheated in chess more than once as recently as 2 years ago. That's part of the picture, but not necessarily what he's being accused of. And unless you're going to try to say that he's defamation proof as a result, which I guess you can try, then they're distinct. Indeed, cheating was an indelible part of Niemann's chess career and reputation well before the alleged events in the amended complaint. He first admitted to cheating happening at age 12, not long after he received his first title, a Federation Master at age 11. I mean, you know, that he cheated when he's 12, I mean, to some degree, give the guy a break. You know, for holding people responsible for what they did at 12, you know? And he became Grandmaster at 17, roughly a year after he admitted cheating at 16. Again, is this really the end of the known world? I mean, you know, he's 19 now, but 12 and 16, maybe he made a mistake once or twice. Okay. But there's a lot more deliberation, I think, when it comes to in-person cheating, because it's harder. It's harder. It's been done. It's usually done with some sort of confederate in the audience by sitting in various positions or, you know, wearing various clothing or somehow transmitting a message based on some sort of pre-agreed signal. It's like, if I stand in this corner of the room, it means this. If I stand in that corner of the room, it means that. So that kind of thing. Or it's even been alleged with computers in people's shoes before. But it requires a lot more deliberation and planning than online, where you can just pull up a chess engine and just start cheating. So I think there is potentially a difference between the two in terms of its calculation, and also cheating in a formalized rated match, I think, is a bit different than cheating in kind of casual online play. But maybe to some people it's not. But, you know, not all evils are equally evil. That's one of the reasons in the criminal system, for example, we have varying criminal statutes at varying levels of severity, because not even all murders are created equal. That's why murder comes in like 10 different flavors, depending on what exactly you did, for example. So we can try to differentiate some of this conduct and also take into account his youth as perhaps some of it. But let's press on. You think he's defamation proof? That's a pretty hard standard to reach, but okay, we'll give that a shot. A Hedinger. We'll see how it goes. Niemann attempts to minimize his history of cheating by claiming he was simply experimenting with chess engine on chess.com as a child, despite Niemann's attempt to pretend otherwise. The amended complaint leaves no doubt that his history of known misconduct is the reason the top chess players and tournament organizers question the integrity of his play. Even accepting his baseless allegations as true, his fatal admissions and lack of plausible allegations make it impossible for him to state any valid claim. Okay. First, the court should dismiss Niemann's 4 state law claims pursuant to Connecticut's Anti-SLAPP. Okay, Missouri federal courts apply the law of the jurisdiction in which the plaintiff resides. Here, Connecticut, when evaluating state law claims that, like Niemann's, are rooted in alleged defamation. Do they? I mean, there's no citation to this. Maybe it will come up later. I suppose that's possible. Normally, you apply the state law of the place in which the tort occurred. So normally you would think a Missouri federal court would apply Missouri state law because this is being alleged in Missouri. But I suppose it's possible Missouri federal courts apply the jurisdiction in which the plaintiff resides. That just seems odd. Okay, we'll see if that's workable. I question that proposition. Connecticut's anti-SLAPP law is a substantive state law that applies here because Neiman admits in his amended complaint he's a public figure. Fine. And he's suing Carlson in other speech that he acknowledges a matter of public concern. Yes, but Carlson in his statements has alluded to very explicitly, mind you, much more explicitly than, for example, in the Amber Heard case. He's alluded to the idea that he has secret information on which he's basing his opinion. And so that communicates potential facts and could be a problem, but okay. Connecticut's anti-SLAPP law does not allow plaintiffs like Neiman to sue defendants for Carlson for protected speech unless they can show probable cause or likely to prevail. Neiman cannot come close to meeting the standard. Well, probable cause can sometimes be kind of low. So, again, I'm a little bit dubious on this. Second, Neiman's defamation claims fail to state plausible claims for relief. As a public figure, Neiman must allege that Carlson knew the statements he allegedly made were false or were reckless about whether they're true. Neiman's own allegations show he cannot make this bar. Read liberally, Neiman appears to allege that Carlson defamed him by insinuating that he cheated at the Cinquenfeld Cup. But Neiman's own amended complaint admits that Neiman has cheated in chess before and played Carlson before. That's not on a dismissal standard. I don't think that quite works. It's like, yeah, you've cheated before, but the question is whether or not you're cheating now, to some degree. Moreover, many of the statements that Neiman attributes to Carlson are not actionable for other reasons, including because they at most reflect opinion. Okay. Third, Neiman's claims for tortious interference in civil conspiracy likewise fails because they're based on the same action and because Neiman has not alleged the essential elements. Fair enough. In defamation claims is often but not always true that other claims rise and fall with the defamation. And I think this is probably in that category of being true, where defamation is probably the thing that causes the rise or fall. So if the defamation fails, the other things fail. And then the antitrust claims candidly reveals what this case is really about, a series of grievances in search of a legal theory. Neiman attempts to make a federal case of an implausible state law defamation case, fails at every step of the analysis. It is not a large harm to competition. Fair. Instead, the only injury he asserts results from the harm he caused his own reputation through his cheating. He's failed to plead any agreement among the defendants, much less a plausible one. Fair. And fails to allege any unreasonable restraint of trade. Yeah, the antitrust thing was pretty weak sauce. So I don't see that being particularly long for this world. For all these reasons, they should dismiss, and because they cannot be salvaged, it should be with prejudice. They should award attorney's fees and costs in connection with Connecticut's anti-SLAPP statute. All right. So do we need to do background? No, I think we all know the background. Okay, we all know the background of the parties. Magnus Carlson kicks ass. Super chess player. They played each other. There were some statements made, blah, 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 blah. We know the drill. Something anal beads. Okay. Let's talk about Neiman's argument, or apologize, Magnus Carlson's argument, rather. Neiman's state law claims are governed by Connecticut law. Please prove that. And Connecticut's anti-SLAPP statute requires their immediate dismissal with an award of attorney's fees. Beyond that, all of Neiman's claims also fail under 12b-6 for independent reason that the amended complaint and materials it embraces do not contain factual content that allows the court to draw a reasonable inference that Carlson is liable for misconduct. Connecticut law offers Carlson an anti-SLAPP defense to all of Neiman's state law claims. You have to first prove that this is the right law to apply. Specifically, Connecticut's anti-SLAPP statute broadly protects speech from meritless lawsuits designed to chill free speech by offering defendants like Carlson opportunity to file a special motion to dismiss at the beginning of the case. The substantive shield would be unavailable to Carlson under Missouri's law because Missouri's anti-SLAPP law is inapplicable here. So they say Missouri state law doesn't apply in this context, so they want to bring Connecticut into it. So according to Missouri statute, explain the statute applies only to speech undertaken or made in connection with a public hearing or a public meeting in a quasi-judicial proceeding. So Missouri's anti-SLAPP law only applies in what might be considered in what would be considered a fair report context. This is normally what we call fair report. If you are reporting on governmental proceedings, so speech made in public hearings, public meetings, or quasi-judicial proceedings sounds a lot like a fair report privilege. And so that really isn't much of an anti-SLAPP law at all, because fair report privilege is another privilege outside of SLAPP, right? So if you're reporting on governmental documents, that's a separate thing. And that's what Missouri law seems to be only covering. So Missouri's anti-SLAPP seems to be weak to the point of non-existence, which, okay, is a call for Missouri to make, and that's what they have. Accordingly, there's an outcome-determinative conflict between defendants that are available under the law of Missouri, the state in which this case is pending, which would seem like the right law to apply, and Connecticut, the state where Neiman alleges he resides and intends to remain, his place of domicile. So this court must resolve the conflict choice of law analysis. Okay, fine. Show me Connecticut law applies. Resolving the conflict between Connecticut and Missouri law requires this court to apply Missouri's choice of law rules. Fair enough. To the extent we're dealing with state law claims, then Missouri state law with respect to choice of law may very well drive the analysis. They're state law claims, so we'll look to Missouri state law to figure out whether Missouri state law applies. And Missouri can say Missouri state law doesn't apply even as to Missouri state claims because it's master of its own law. So if Missouri wants to, it can say, okay, well, here's some Missouri law. And by the way, also it doesn't apply if XYZ. Then go apply some other law. Incidentally, this is more common in contract because there's choice of law provisions in contract. We'll say like this state's law will apply, regardless, incidentally, of where the case is heard. But a state could do this if they want to, fine. And there might be valid reasons for Missouri to do this, right? Missouri might think, well, maybe our state law shouldn't be the state law that applies because this really is an issue that arises under some other state, so go do their law. I mean, okay, fine, whatever. Missouri determines choice of law rules in tort actions by considering the following factors to identify the state that has the most significant relationship to the particular claim. Okay. The place where the injury occurred. Okay. The place where the conduct causing the injury occurred. The domicile, residence, nationality, place of incorporation, place of business of the parties. And the place where the relationship, if any, between the parties centered. Most of those factors seem like they favor Missouri. The place where the injury occurred, we're bringing it based on statements made in Missouri, as I understand it. So, yeah, the place where the conduct causing the injury occurred. Yeah. So the place where the conduct caused and the place where the relationship between the parties is centered with respect to this seems to favor Missouri. Okay. Thank you, Katri, by the way, for giving me notice for all BS giving me 50 gift memberships to the channel. That is incredibly appreciated. Thank you very much for bringing it to my attention. It flashed on screen, of course, and we do really, really appreciate everyone who helps to support this channel, particularly with the gift memberships, because it helps to encourage other people to join as members. So it costs you nothing more or nothing. It doesn't cost you any more than a super chat does. But one of the nice things is, maybe some percentage of those people will choose to continue their gift memberships into the future. So you help the channel to grow, not only in the immediate, but also in the long term. And 50 gift memberships is an incredible gift membership donation. Thank you very, very much for that and helping the channel to spread. And all those people who are getting those gift memberships, don't feel bad when it comes to the end and be like, oh, your membership is lapsing, please renew. Hey. Anyways, I do appreciate it. Thank you very much. It's all BS for your kind super chat memberships. Okay, anyways, let's continue on with the analysis. As applied to Neiman's specific tort claims, the place where the injury occurred, here, Connecticut, where Neiman resides, is the most important consideration in determining where the site bears the most special relationship. I don't know that the injury occurred in Connecticut. That doesn't sound right. Accordingly, Connecticut's substantive law applies to the claims and Carlson's defense. Okay. In particular, for Neiman's slander and libel claims, the residence of the party allegedly defamed is the most important consideration in choosing applicable law, whereas here, the plaintiff claims widespread dissemination of the alleged matter. That sounds a little bit more promising. Although I note that's from a federal court, the 8th Circuit, rather than Missouri State. So Missouri might not see it that way. But, okay. We are in federal court after all, so federal precedent is relevant in a federal court. Missouri is part of the 8th Circuit, is it not? Let me just double check my federal circuit map. Yes, it is. So that is binding law on this court. So apparently there is a 8th Circuit, which is binding on this court because we're in federal court, that says that Missouri is where the plaintiff maintains his principal place of business in result to alleging a worldwide dissemination. That's a very short quote, but at least it's something that somewhat speaks to that proposition. How faithful a quote that is, or if there's other law to the contrary, isn't expressed here, but hey, something. See you later, Mark. Thanks for dropping by. Thanks to the 155 of you who are currently here. Was the link for membership? It should be in the video description. The link for membership should be in the video description. And if not, the bot gives you the link from time to time. So just click on those things. An injury from defamation has a center in one place of domicile. Connecticut law independently bears the most significant relation to Neiman's tortious interference in civil conspiracy claims, because it's just for defamation. Courts employ the most significant relationship test to give the weight to plaintiff's residence as the place where the injury occurred. I don't know, man. The statements were made in Missouri. That was the place where they were published. I'm not sure I buy this analysis. I'm not really feeling like Connecticut law coming into this mix makes sense. Like, it is a factor. I'll take your word for it. It's a factor to be considered where the plaintiff lives. But this is the place where they were published. This is the place from which they were disseminated. And so, even assuming Connecticut is a valid choice, the plaintiff does get their choice of place. And this is the place where the injury occurred. So I'm not really feeling Connecticut state law on this one. But, okay. Without really digging into the precedent and really getting into it, I'm not sure, but it feels a little iffy. Missouri substantive law applied to a tortious interference claim brought by plaintiff residing in Missouri, where other parties were involved in Missouri and California, and alleged interference was conducted over telephone and mail. Applying Missouri choice of law rules to tort claims, including civil conspiracy, and concluding that Missouri law governs where the alleged injury occurred in Missouri, and Missouri is the location of business. Well, that's the problem. The injury did occur in Missouri. The principal place of business. Yeah, no. As with Neiman's defamation claims, any injury was felt in Neiman's state of residence. That is probably true. And even the most significant relationship analysis were inconclusive. Missouri law establishes the trial court should apply the substantive law of the place where the injury occurred which again points to Connecticut where Neiman resides. Yeah, I'm not buying that. I'm not buying that. I mean, they're you know, you got to try. You got to try because Missouri's anti-SLAPP basically doesn't exist. And so, like, well, we can try to bring Connecticut into this mix, but I'm not seeing that based on this analysis. Yeah. This court should dismiss Neiman's state law claims under Connecticut anti-SLAPP statute because they're based on Carlson's exercise of free speech and because Neiman cannot demonstrate with any particularity any circumstances giving rise to a meritorious claim or show probable cause he will prevail. I don't know about that, man. I don't know about that. That statement that he posted on Twitter, that like page-long statement that he posted, the problem is, like, as long as we have a valid basis to be in Missouri for any reason for jurisdiction, then we have a valid reason for every reason. So, like, even if you can't get to him for the statements that happened in Missouri, because I'm not sure that particular statement was made in Missouri, but I don't know. Maybe it was. I'm not sure on the timing of that. But assuming it was or it wasn't, since you have jurisdiction for any reason, I don't, yeah. Many courts have held that various states' anti-SLAPP statutes apply in federal court, and some have ruled the opposite, because the statutes serve the distinct function of protecting these specific defendants that have been targeted with litigation on the basis of speech. So, yeah. This court should follow those decisions and apply Connecticut's anti-SLAPP statute to dismiss the claims because the statute would apply in Connecticut state court had it been filed there. But why would it be? What would be the basis to file it in Connecticut? You're admitting to so this argument's weird because this argument is basically consenting to jurisdiction in Connecticut, which seems like an odd choice because presumably that would be even more convenient for Neiman. But okay. It's substantive within the meaning of Erie and does not squarely conflict with the federal rule. Well, yeah, this is another reason for this federal court to avoid it, right? To avoid the question, because the issue of whether or not SLAPP law applies or not can vary depending on what federal court you're in, and you can wind up with some really weird results on what federal courts will and will not recognize the state's anti-SLAPP. So if you don't bring Connecticut law into this at all as a federal court, then you don't have to worry about whether or not the federal court will recognize it because it's just irrelevant from the get-go. So Connecticut anti-SLAPP statute would apply in Connecticut state court had Neiman filed there. I'll just skip this analysis because I'll just assume that's true for the purposes of our present analysis. Well, let's actually read it so we can determine whether or not it matters. All right, so let's go with the contrary assumption. Let's go with the contrary assumption and assume that we're going to say, okay, we're going to go look at Connecticut law. Okay, having done that, having ruled that Connecticut law is applicable in this context, we still have to rule under whether or not it would meet the definitions of Connecticut law, right? Because our first question is, should we apply Connecticut law? Then once we do that, we can say, okay, well, what would Connecticut law require? So, okay, fine. Let's reach the contrary assumption and assume that we're going to apply Connecticut law and see what happens. Connecticut anti-SLAPP statute applies to Neiman state law claims because they're based on Carlson's free exercise right regarding a public figure. Under the statute, free speech means communicating in a public forum on a matter of public concern, and matters of public concern including issue relating to a public figure. Fine. As discussed earlier, all of Neiman's claims against Carlson are based on allegations that Carlson accused Neiman of cheating through a series of actions and statements which Carlson exercised his right to speech in a forum. All right. Specifically, the amended complaint targets Carlson's statements and actions in publicly broadcasted chess tournaments, but broadcasted from where? That's part of the problem. On Twitter and in press interviews. Where did those occur? It's part of the problem. Neiman himself alleges Carlson's statements were intended to produce an effect on the chess community and the public. Neiman's allegations also establish that he's a public figure, meaning the speech about him in that capacity constitutes a matter of public concern. I'm not sure whether or not that's true, whether or not he is a public figure, but let's read. He might be in the relevant context, and courts are fairly liberal these days about public figure for a limited purpose. So is he a public figure within the meaning of the chess world? Probably. According to Neiman, he not only earned several chess titles at a young age, but he rapidly developed into the 40th best chess player in the world after becoming the youngest ever winner on a Tuesday night marathon at the oldest chess club in the United States. Neiman's also made a lucrative streaming career in which he's played chess online for a wide audience, traveled the world to compete in tournaments for which he's paid thousands of dollars. Neiman's own amended complaint therefore demonstrates he assumed the role of a special prominence in the affairs of society. I think that public figure law tends to be a little bit too widely applied, but it is the state of the law. So, is he a limited purpose public figure for the chess world? Given the state of the law, probably. So we'll assume that this is a public first person in public manner, and therefore we're under the stricter definition. We'll assume that is fine. Accordingly, Neiman's own allegations establish the threshold requirements for the applicability by preponderance of evidence. Okay, and then apparently there's a case where the court granted the special motion to dismiss because they established by preponderance of the evidence the claims fit within the protection of the anti-SLAPP when allegations showed a newspaper coverage constituted the exercise of free speech in a public forum. Carlson therefore would be able to invoke Connecticut's anti-SLAPP in Connecticut State Court for all these claims, satisfying the first requirements. We'll assume that's true. We'll assume the first element of it. That's fine. Assuming we're going to apply Connecticut state law in the federal court, we will further assume that we meet the definition of the first standard. Fine. Connecticut's anti-SLAPP is substantive and doesn't conflict with federal rules. Connecticut's anti-SLAPP applies in this court because it creates a substantive statutory protection. This court previously has concluded that Missouri statute intended to call an early stage of litigation a meritless lawsuit that was bound up with rights and obligations created by state law. So the Eastern District, which is non-precedential because it doesn't come from the circuit court, but it's a persuasive case. So a Missouri district court at one time applied this to Missouri state law, incidentally, not even Connecticut state law. But district courts don't necessarily have to be consistent with themselves because they're not binding on themselves because they're district courts. So to the extent they were binding on themselves, they can just overrule themselves. So decisions from a district court are informative, they're persuasive, but they're not binding authority like a court of appeals decision. It helps a lot if you have a lot of district courts or a lot of district court decisions, and you can show this is the overall trend of the law, right? So if you have a couple of them, that's really helpful. It's still not binding, but obviously the more you have, the more it represents the zeitgeist, and more likely that the Court of Appeals would agree. Different judges in different cases coming to the same conclusion is somewhat more indicative of where the law is developing. This is because requiring dismissal for failure to adhere to a statute that the legislature clearly intended to influence substantive outcomes. The same is true as Connecticut anti-SLAPP statute. Its legislative history confirms the purpose is to allow defendants who, like Carlson, are sued on free speech rights. The First, Second, and Ninth Circuits, among other courts, have concluded that certain anti-SLAPP statutes afford defendants substantive rights that should be applied in federal court. Please take note, we're in the Eighth Circuit. It is true the First, Second, and Ninth Circuits have said this. I know the Fifth Circuit, I believe, has disagreed. Presumably, the Eighth Circuit hasn't spoken to this issue either way in the continuing divide of federal authority on this issue. As these courts have recognized, enforcing a state substantive law in this matter does not conflict with the federal rules of civil procedure. This is because anti-SLAPP asks an entirely different question than Rule 12 or 56, namely whether claims rest on the SLAPP defendant's protected First Amendment activity and whether the plaintiff can meet the substantive requirements of the state law. Put differently, anti-SLAPP statutes fashion a supplemental and substantive rule to provide additional protection beyond those in the rules. I mean, I tend to think that's probably true, but then again, there is a divide of authority on this issue. And they cite the First, Second, and Ninth Circuits, and not very eager to point out circuits that have disagreed on this point. Anti-SLAPP statutes vary from state to state, and some courts have concluded certain anti-SLAPP rules cannot coexist with federal rules. For example, although the Second Circuit previously upheld a trial court's application of provisions in Nevada, which is in the Ninth Circuit, so I tell you, like I say, like it's rare, but not unheard of for one state to have to apply a different state's law or one circuit to apply state law from a different place. So we're in the Eighth Circuit, but we're looking at Ninth Circuit case law because we were trying to determine Nevada in Missouri. So a Missouri federal court was trying to determine a Nevada state law because sometimes that happens, right? We've concluded for the purposes of this thought exercise that the Missouri court is applying Connecticut state law. So, you know, it happens sometimes. Whether it should happen here is doubtful in my mind, but we'll continue to presume the answer is yes to see what difference it makes. Relying on the analysis, the District of Connecticut filed the case in unreported decision declining to apply Connecticut's anti-SLAPP law in federal court. So the District of Connecticut refused to apply Connecticut anti-SLAPP law. Again, not a binding decision on this court because it's a district court decision and also from the wrong circuit. And this has happened before. Texas, which is in the Fifth Circuit, the Fifth Circuit said Texas anti-SLAPP law doesn't apply because it's procedural. So the Fifth Circuit, which includes Texas, said Texas anti-SLAPP law does not apply in federal court. But the Ninth Circuit said Texas does apply in the Ninth Circuit. So ironically, if you're a federal court in Texas, you do not apply Texas's anti-SLAPP. But if you're in California, you do. So the District Court of Connecticut saying we're not going to apply it is persuasive authority as to this court. Strange things happen, my friends. Strange things happen. But this court is not bound by that decision and it shouldn't follow here. Well, that much is true. It's definitely not bound by it. Reviewing the issues afresh, it's evident that Connecticut's anti-SLAPP statute supplements rather than conflicts. Connecticut anti-SLAPP statute does not ask the same questions. Instead, focuses on when defendants were wrongly targeted for exercising. And unlike the anti-SLAPP laws of Maine and California, Connecticut's anti-SLAPP works in tandem with Connecticut's rules. Accordingly, rather than creating conflict, Connecticut adds an additional unique weapon in a pretrial arsenal. So some federal courts have declined to apply Connecticut state law on this issue, including the Federal Court of Connecticut. So we could reach a difference there. Declining to apply the statute in federal court would result in inequitable administration of justice between defense asserted in state court and the same defense in federal court. To discourage forum shopping and avoid this inequitable result, they should apply Connecticut's statutory shield. Okay. We will continue to assume for the purposes of our continuing exercise that the court will apply Connecticut law, which seems unlikely, but we'll continue to assume it because we need to figure out if it's going to make a difference. All right, so if we conclude that we should apply Connecticut law, is it triggered? Because Neiman has not met and cannot met his burden to demonstrate to the court that there's probable cause, they'll prevail in the merits with particularity. Each of the state law claims should be dismissed. First, Neiman has failed to allege essential elements of his state law claims and on the facts of the face of those claims cannot show probable cause. In this context, probable cause is a bona fide belief in the existence of facts essential under the law for action, and such would warrant a person of ordinary caution, prudence, and judgment under circumstances in entertaining it. That's not much. As discussed below, Niemann's amended complaint is missing factual allegations. Second, Niemann cannot overcome Carlson's defenses. Courts dismiss action under the anti-SLAPP for failure to satisfy probable cause, where a plaintiff cannot overcome valid defenses. You're kind of like bootstrapping yourself into that argument a little bit. Carlson has several such defenses, including that Niemann has not alleged actual malice, that conduct Carlson allegedly engaged in cannot form the basis of the defamation claim. Qualified privilege shields Carlson from liability for his alleged statements to tournament officials. Okay, well, we'll see. And all of Carlson's alleged defamatory statements are protective opinions. How's everyone doing, by the way? Let's take a brief break just to check in with everyone. To the 151 of you who are currently in chat, how are you doing? How are you feeling? Feeling good? Did you have a good Thanksgiving? I hope you did. I had a really nice Thanksgiving. Spending some time with my friends and family. That was plus. Bonus. Glad to be back. Hope you're enjoying this in-depth legal analysis here. It is one of the things we like to do on this channel. Try to provide some thoughts, commentary. Let's see what the weather looks like. It looks like it's clearing up a little bit here. That's nice. All right. How do you join? The link isn't working. Is it not? It should. Is the link not working? That's weird. Peace Penny, though the link is not working. No, one of this video description might be broken. Yeah, one of the video description might be broken. Look for the link from the bot. I'll have to fix it later. There's always something, man. It's always something. Because each alleged defamatory statement constitutes a separate cause of action, Niemann is required to plead necessary elements for each separate statement. The elements are that they published a defamatory statement to a third person, the defamatory was published to a third person, and reputation suffered. In addition, because Niemann is a public figure, he must allege actual malice. As detailed below, Niemann is neither pleaded with the requisite specificity nor plausibly alleged Carlson made defamatory statements. The jumbled morass of asserted statements and conduct by Carlson alleged in the amended complaint fails to meet Niemann's burden of specifically identifying what alleged defamatory statements were made, by whom, and to whom. Imprecise pleading is not permitted in a context of alleged defamation. Okay. I'm not sure about that. Niemann's defamation claims also fails for the independent reason that Niemann has failed to plausibly allege that Niemann acted with actual malice as to any alleged defamatory statement. Actual malice requires that a statement, when made, be made with actual knowledge that was false or reckless disregard. Reckless disregard may be shown when an individual publishes a defamatory statement with a high degree of awareness of probable falsity or retaining serious doubts. Given the allegations in the amended complaint and Niemann's acknowledged history of cheating, Niemann has failed and cannot plausibly allege that Carlson knew his statements were false, had any awareness of falsity, or entertained serious doubts as to truth. One of the problems is we have this defamation by implication, and the implication might be relating to the anal beads thing. And as to that, it's a little bit unclear. You might win on the question, at least in part, is can we get to discovery? Like, you might be right after discovery, but where you can reevaluate this, but I'm not sure out the gate. I might also break this video up into different parts. Niemann claims that Carlson falsely accused Niemann of cheating at the Cinquenfeld Cup, but he does not allege and cannot allege any facts to support this conclusory assertion. Highlighting the lack of any such allegations, Niemann relies exclusively on post hoc sources, such as the claimed lack of statistical evidence of cheating in statements made by the organizers. There's no indication of cheating. The after-fact statements could not have influenced his personal impressions. Fair. I mean, for some of them, maybe, depending on the timing. Nor do the organizers' alleged statements prove that he did not cheat. To the contrary, Niemann concedes in his complaint that the type of anti-cheating measures that could have helped rule out cheating were not in place during his match. Further, Niemann's own allegations demonstrate that each of Carlson's allegedly defamatory statements were personal impressions. Niemann acknowledges that he played Carlson prior to the game, meaning that Carlson has had a history with Niemann, informing his evaluation of his performance. And even if the statement Carlson allegedly made were in fact accusations that Niemann cheated in the cup, the amended complaint illustrates that those statements have a basis in fact. Niemann concedes that he's cheated in the past and incorporates by reference documents in which he admits he's previously been accused of cheating in the past. Finally, Niemann's bald assertion that Carlson acted with reckless disregard are insufficient to plead malice. And they're particularly implausible given numerous facts alleged by Niemann undercutting his insistence Carlson somehow knew his alleged defamatory statements were untrue. On the contrary, Niemann's own allegations show he's trying to hold Carlson liable for sincerely held beliefs that Carlson formed on the basis of his own interactions with Niemann. Yeah, I'm not sure about that. That seems kind of weak. The problem is some of these statements seem to create a defamation by implication, and the implication is informed by the zeitgeist, which goes to this whole vibrating beads innuendo. And I don't know. Like, so for some of his statements, for some of Carlson's statements, maybe. But for all of his statements, I don't know. So my initial inclination here is to deny at this point, but to allow for discovery. Because if I were a judge, and then I might dismiss some of these counts on like a summary judgment or a motion to dismiss that was revived. But the problem is there are some facts here that are in dispute. And yeah, I don't know. The vibrating beads thing didn't come directly from Magnus. That's true. The vibrating beads didn't come directly from Niemann or directly from Magnus. That's very true. Magnus Carlson never said how he thought he was cheating. But Magnus Carlson, in his Twitter statement where he did that page-long thing, he said, and I'm paraphrasing, it was in his last paragraph, but he said, paraphrasing, that, there are other things I'd like to say, but I can't say them without Niemann's permission. And so Magnus Carlson is expressly expressing that he has information he's not telling. So his opinions, like that he's cheating, which might be a view of opinion on its own terms. And of course, defamation has to be understood in context of the whole statement, right? So a statement like, I think that he was cheating, which might be an expression of opinion, right? If the opinion is based on hidden facts, then defamation by implication. And here, the hidden facts are expressly provided for by Carlson. He says, I have things I know that I can't tell you. So he's telling you he has hidden facts. And then what are the hidden facts that are alleged? Well, because this whole vibrating beads thing had been in the zeitgeist, had been the dominant thing of the zeitgeist, the hidden facts that would most readily be brought to mind by the reader of the chess community in particular would be the beads. So because of the context and the overall tenor of where these things were being made, although Carlson himself did not explicitly say beads, because he said, I have hidden facts that I'm not telling you, and the zeitgeist was beads, we go to the reasonable man test. What did the reasonable man in the chess community, incidentally, what did the reasonable man in the chess community, because the letter was written to the chess community explicitly. So what did the reasonable man in the chess community, was the reasonably informed person in the chess community understand the hidden facts to be? And the hidden facts could very well be the beads. So that's the problem. By saying I'm relying on facts I'm not telling you about, it can be understood to communicate those facts. That's defamation by implication. So that's the nature of the problem. Sulfa says the beads in question comment was a joke by a YouTuber after the comments. Maybe. We'd have to get into the specific timing. I think that some of these statements were made after the beads thing was already discussed. I could be wrong about my timing. So if you're correct that the beads thing didn't happen until after Magnus Carlsen's statements, then you're absolutely correct. You can't read the zeitgeist that didn't exist under the statements. And obviously the statements he made to the Torment director couldn't be based on that, because the YouTube video certainly came after the Torment happened. But I think the initial speculation came like that day or the next day. It was pretty prompt, as I understand the timing. And Magnus' statement on Twitter came a fair amount after that, I understand. But I could be wrong on the timing. So if all of Magnus's statements came before the zeitgeist, then you're right. But I don't think that's true. But thank you for the chat. Neiman's failure to identify specific statements or plausible actual malice is on grounds to dismiss. But the claims also fail for a separate reason that none of the statements is actionable. While Neiman amended complaints obscures the nature of the grievance, he appears to complain they defamed him by withdrawing from the cup and resigning from the cup game, expressing concerns about Neiman cheating to Kordowski, a chess Torment director, and expressing his opinion they cheated. Well, that last one's where things maybe run into a problem. Because even if it could be understood as opinion on its own terms, the sentence in isolation, we have to understand in context of the statement and context of what the reader would understand. First, as a matter of law, Neiman's allegations regarding Carlson's resignation cannot support defamation. Under Connecticut law, defamation is an oral or written statement. That's typically true. Accordingly, to the extent Neiman's defamation claim are premised on conduct, the claims fails as a matter of law. Okay, I'll give him that for the actions, the pure actions. Yeah. Second, to the extent the defamation claims are based on Carlson's alleged statements to chess Torment officials, those statements are all protected by qualified privilege. Qualified privilege exists where there's an interest to be upheld, a statement limited in scope to purpose, good faith, proper occasion, and publication in proper manner to proper parties. The statements to the Torment directors are probably protected for this reason. So if you get those thrown out, then you still have to show other statements were made in Missouri, preferably after the zeitgeist. If you're going to get into Missouri, if you're going to go Missouri law, right, then the statements to the Torment director, if they are privileged, which they probably are, you can't use those. And even if you could, You can't read the defamatory context on them because the zeitgeist didn't exist yet. So those are out. So I think that's, you could try to do some sort of echo back thing. You could try that. You could try echo back, because you could try to say that because even if Carlson's statements were made out of state, you could try to say that because the statements related to the torment in Missouri, that's enough connection to Missouri, enough targeting of Missouri. So you could try that. So even if Carlson made the statements when he was not physically in Missouri, because they related back to the thing that happened in Missouri, that might be enough connection. You could try that if you're Neiman. Do I have any insight into how long the saga takes to conclude? Not right now, I don't. It depends on a whole bunch of things. It depends on whether or not the court will grant the motion to dismiss. And as I've been expressing, I have my doubts. I have my doubts Connecticut law applies here. And if Connecticut law doesn't apply, then basically all this that we've been reading goes away. We've been assuming it applies to see if it does apply, how much protection it gives us. And, we got some protection, but, maybe not enough to get where we need to be, assuming it applies at all. Assuming Carlson is in fact experienced concerns about Neiman's cheating to the torment director, such statements would not be actionable. Neiman's own allegation shows that both Carlson and the director had a common interest in preventing cheating at the torment. Okay. The alleged statements to this torment director are thus protected. Neiman can only defeat qualified privilege by showing actual malice, which at the time he made the statements to the torment director are going to be pretty hard. That he knew he was lying at that time, that's going to be tough. So, yeah. Carlson's alleged statements are non-actionable opinion. Finally, Neiman's claim should be dismissed because the alleged defamatory statements at most amount to non-actionable opinion. Statements of opinion, even if negative, cannot as a matter of law form basis of defamation. That's certainly true. As discussed earlier, Neiman's own allegations demonstrate that Carlson's alleged defamatory statements constitutes his own personal impressions based on firsthand observations of what was already known through the chess community. Accordingly, Neiman's allegations regarding Carlson's purported statements cannot support defamation as a matter of law. This is conclusory. This is totally conclusory. The problem is you're not showing that they're opinions. And because of this whole defamation by implication thing, I think you have real problems there. So I'm not so sure about that at all. So I am really not feeling this motion to dismiss from Carlson for these reasons. I'm super doubtful that Connecticut state law applies in this context. A Connecticut federal court has already said Connecticut state law wouldn't apply in federal court. And as I point out, this court can disagree with that conclusion. Apparently, the Eighth Circuit's never spoken to this issue one way or another. So I guess the district court has to make something up. But even if they do apply Connecticut state law, even assuming arguendo it does apply, I don't think you can get there for some of these statements. And the whole relating back thing, yeah, I think you have problems. So you might at best get a motion to dismiss without prejudice, because the district court might say, well, you didn't quite prove actual malice. You didn't quite prove the whole tying it back thing. So either leave to amend or dismissal with prejudice. But dismissal without prejudice, assuming the district court just doesn't allow it to proceed at all, I think that's a bit beyond. Hey, Peace Pony, I see that you became a member. Thanks for finding that join button. I appreciate it. I really do. Thank you very much for trying to work through the technical difficulties of apparently the link in the description is broken. Hopefully the link in the chat popped up from time to time. Is the bot working? Let's see. It might not be working. That would be annoying. I don't think the bot's working. Lol. Always something. It's always something. Yep, it's turned off. I'm not sure how that happened, but it did. That's great. Come on. No one likes seeing the sandwich. No one likes seeing the sausage getting made. Apparently it's still, well, hopefully it will show up at some point in the future. Yeah, Nightbot is fortunately working, but Streamlabs is not working. Nightbot is working, but Streamlabs is not working right now. I just bought a year's membership of Ultra too. You like the Christmas colors in the background? I thought they worked out well today, so I'm glad you like it. Chat alerts are working. Come on. I seemed happy when I was streaming from my parents' house. Do I ever think about moving back to that area? I was happy to be with my parents. I had a great time. It was nice to be with them. You know, it's always nice to be with your friends and family during the holiday. Do I think about streaming? Do I think about moving back there sometimes? Yeah, I do think about moving back sometimes. Right now I'm thinking about moving to Houston, but you know, anything's possible. So, but I appreciate the super chat or the chat. Thanks very much. And come on, bot. Well, it says it's enabled, so we'll see if the bot wants to show up at some point. Maybe it'll take some minute. Let's get back to the stream. As discussed earlier, Neiman's own allegations demonstrate that Carlson allegedly defamatory statements constitute personal impression based on firsthand observation and what was known. Daniela says, does the fact that Neiman is an admitted cheater hurt his defamation claim? Possibly, but there is a potential way for Neiman to potentially get where he wants to be. So we'll see. I signed up for a year of Streamlabs membership. I'm streaming through Melon, by the way, rather than OBS right now. And I signed up for a year of the premium, along with a whole bunch of other things too, like stream layouts and all kinds of cool stuff. So I made some changes. I changed the donation page for the channel so that it's like a little bit different. And I'll keep playing with things, but you know, it was a business expense. So yeah. I have to do my taxes next month. That's going to be interesting. I'm going to have to write a big check because YouTube doesn't take out withholdings, right? So I'm going to have to write a big check. I'm not sure how big a check I'm going to have to write, but I'm guessing it's going to be pretty big. Hello, Radiant. How are you doing? I love you all. Thank you, chat, for being here. You brighten my day. Like his defamation claims, Neiman fails to adequately allege that claim for tortious interference. A tortious interference claim results in a business relationship between the plaintiff and another party. Defendant's intentional interference with the business relationship. As a result of the interference, the plaintiff suffered. Neiman has not alleged that Carlson had any actual knowledge of any alleged contracts or business relationships. True. At least I don't think I have to pay taxes in Texas, so you know we'll figure that out. Now the business is registered here, but I don't think I have to pay anything. We'll see. Nowhere in the amended complaint does Neiman allege that Carlson had actual knowledge of Neiman's opportunity to attend the Tata Steel chess tournament or his desire to play. Neiman cannot avoid his obligation to plead actual knowledge by pointing to Carlson's position as a fellow member of the industry, because general knowledge in the industry cannot substitute for actual knowledge of a specific contract. Fair. That's fair. For these reasons, Neiman's tortious interference claim fails. Second, Neiman has not adequately alleged that Carlson has any intent to interfere with any contracts. To allege intent to interfere, they must plead at least some improper motive or improper means. In other words, the plaintiff bears the burden of alleging lack of justification. Yeah, I think it rises or falls with the defamation, at least for preliminaries. But I think for preliminaries, it definitely rises or falls with the defamation. Finally, Neiman has not alleged any factual basis for his contention that Carlson alleged conduct was a proximate cause, such as being disinvited from the tournament and the match against Keimer. Yeah. Just remembered something. Excuse me 1 second. Okay, great. All right, great, excellent. All right. He's not plausibly claused in a claim for civil conspiracy. It was kind of thin. The court should dismiss Neiman's civil conspiracy claim because he's failed to adequately allege an underlying tort as required to state a claim for civil conspiracy. Neiman has also failed to sufficiently allege the required elements for civil conspiracy under Connecticut law: a combination of two or more persons to do a criminal or unlawful act by criminal or unlawful means, an act done by one or more of the conspiracies in furtherance, which results in damage. That sounds about right. In fact, Neiman does not allege that any defendants were communicating about their alleged statements at all. The only allegation Neiman provides is his failed effort to conjure an agreement in timing of defamations of asserted acts, alleging that the sudden ban by chess.com was at the precise time Carlson accused Neiman of cheating. Yeah, that's a little thin. The conspiracy claim is thin. It's thin. So he might lose it on the motion to dismiss. So I think the conspiracy claim is thin. And if the conspiracy claim dies, then Hakura's out of this thing completely. Not that I think that he's a conspirator in any event anyway. So even with the conspiracy, I don't see how Hakura steps into this lawsuit. By the way, not for nothing, but Hakura Nakamura, if you're out there somewhere and you're interested in having a 1,000 rated chess player as a legal commentator on some of this stuff, feel free to reach out. I can comment about some of the stuff, and you can kick my ass in chess and make fun of my appalling skills. So if any of you guys out there know Hakura and he's looking for a collab with a lawyer who wants to talk about this stuff, holla. He's an interesting guy. I think he's fun and entertaining. Yeah, I think this is pretty thin. I'm sure his lawyers are looking at this like, yeah, no, I don't think so. My grifting skills have become top notch. Hey, I'm learning from the best. I am learning from the absolute best. Speaking of which, hold on. Now is a good time for some more grift. To the 100 of you who are here. Hold on. Because we have a potential sponsor. And I'm going to read this script. This video was sponsored by Sutton Digital Marketing. Every business owner knows how valuable it is to rank at the top of Google, but this is very difficult to do. Sudden Digital Marketing specializes in helping law firms and other businesses rank at the top of Google for target AdWords. I personally looked at the reviews for Sudden Digital Marketing, and overall, they are very positive. At the time of making this video, Sudden Marketing has 5 stars on Google and Yelp. They are experts in helping businesses reach the top of Google for target keywords. They offer competitive pricing and will never lock you into a long-term contract. One of the best ways to help support this channel is by supporting sponsors of this channel. If you're an attorney or own another type of business and you want to have help to help you rank at the top of Google, please consider reaching out to Sudden Digital Marketing. They do have 5-star ratings on Google and Yelp, so that's a fairly positive indicator. And their overall reviews are pretty good. You can learn more about Sudden Digital Marketing by visiting their website, Sutton DM. That is SUTTON.com. Make sure to tell them that Uncivil Law has sent you. So please look at Sudden Digital Marketing if you're interested in having your business have a better Google ranking. Sudden Digital Marketing, Sutton DM can help you. All right. So, great. Bo Johan, I'm not beyond other people sponsoring this channel. But you know, they were the ones that reached out, and I was like, okay, well, we can do that. Notwithstanding Neiman's assertion that there would be no reason for chess.com to suddenly ban Neiman immediately after defeating Carlson, the alleged close timing of these unilateral actions does not amount to a plausible allegation of coordination or agreement among the defendants. Neiman's failure to allege any facts supported by the existence of this agreement among defendants dooms his civil conspiracy claims. They are pretty weak. They are pretty weak in this world. Also, of established titles is looking for new people to grift. I will totally grift it, because if you didn't know that you couldn't really call yourself a Scottish lord, then I don't know what to tell you. So I will grift established titles if they're out there looking for new things. We could have a bacon producer as a sponsor. That'd be kick-ass. As discussed above, not so much on the antitrust. Okay, so yeah, that pretty much wraps up that complaint. Let's see what else is going on here in this lawsuit. It doesn't look like Hikuro has yet filed, so I guess we'll have to do that another day. Yeah. All right. So should we save the other ones for another time? I think so. I think we could do the other motions to dismiss another time. This has been an hour-long stream, and it's nice to get back, but I can use a little break, and I need to make some soup and stuff. So, you know, remember to check out Sudden Digital Marketing, suttondm.com. Remember to tell them Uncivil Law sent you to help with your ranking related needs. So I appreciate everyone who's been donating to the channel today, all the people especially who have been giving memberships and as a gift is really appreciated. Let's see. If there were any super chats today. Let's see. Today is December the 2nd. Only the one super chat today, as opposed to buying membership. Sledge and Wedge gave $3.14 at the top to say slice of pie to start your day. Court is in session. Awesome. Very, very good. So all that good stuff. So yeah, I'm going to take a break for now. I might cover the other 2 things today. I also want to see if Hikuro files today, because that would be pretty interesting to read his thing. But so far, so good. And I hope all of you are well. If you've been enjoying this stream of Uncivil Law, please don't forget to do the YouTube things. Like, comment, subscribe. Did you know for a mere 99 cents, you can help support the channel? It's true. 99 cents a month. It's literally the least YouTube will let me charge you. And you can help support Uncivil Law so that he can get things like memberships to Melon and streaming apps so that his streams can be good and interesting and all that good stuff and, all the rest of it. So please remember to do that, all that stuff. I've been on Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.